Продовжуємо роботу.
We continue our working day at Ukraine Crisis Media Center, and the next topic is recent changes in legislation regarding child support collection. Our speaker is Mykola Kuleba, Commissioner of the President of Ukraine for Children's Rights, Oleh Prostybozhenko, a lawyer, head of the Center for Family and Legal Studies, head of the section of Economic and Moral Disputes of the Ukrainian Bar Association, Hanna Haro, lawyer, Chairman of Family Law, Committee of Ukrainian Public Organization Association of Advocates of Ukraine, and Svitlana Savytska, lawyer, Associate Professor of Justice Law of the Faculty of Kyiv State Maritime Academy, named after hetman Petro Konashevich-Sahaydachniy. Mykola Kuleba is given the floor. Good afternoon, everyone. I would like to thank those who are present here today, to the Association of Advocates of Ukraine, and we have the Memorandum of Cooperation with this organization. And starting our activity 2 years ago, we thought through what should be the main in our activity and what changes should be made into legislation, because each third claim that goes to the office of Commissioner of the President, it concerns the collection of child support, the disputes between parents, and the statistics clearly shows that in 10 or 15 years, the number of single mothers who officially are registered as single mothers, their number increased 20 times. And this shows that this problem is really acute, and the plaintiffs concerning child support, this is about 7 million claims and petitions. So these are billions of hryvnias of arrearage, and this is the debts that should be paid. And one woman gave birth to triplets, and her husband left, and the court ordered 250 hryvnias per child, but this man do not pay, and he said that he has another family and other children. So we have a lot of petitions concerning these issues. When the law was adopted in the parliament, we saw that we need to explain to people what these changes bring and why they are so important. In order to provide more information, what changes are introduced by this draft law. So today we are going to discuss many issues concerning the amount of child support and the mechanism how to collect them. But I would like to say one important thing. We should understand that the work does not end here. When we started this work, there were many proposals, and I understand that some people will be dissatisfied, that the obligers are not properly punished. But from the very start, we had many opinions on this, and we studied international practice. And before I provide the mic to my colleague, who will go in more detail about this draft law and this law that was adopted, and we start to work on the new draft law that will concern more rigid punishment for those who do not pay child support. And what is important in this law, for the first time it is identified that the owner of the money, the child support, are children, and the adult can use this child support, but the child is the owner of child support. And if someone does not pay child support, we mean that the child suffers. They are not provided with relevant living standards, and in the majority of cases, mothers, single mothers, they complain that they do not get enough money from their former husbands, who unfortunately avoid payment. And About further activities, I would like to say that we will move along such ways. First, we would like to introduce an active mechanism of transformation or transforming of the rearage, and that should be the right of children for real estate, and not only through enforcement service, but if there is such indebtedness and if the obliger has property, so this property can be used as a payment for children, and also the elaboration of the mechanism to inherit the child support. We study now the experience of other countries, and in many European states this issue was resolved. And if the obliger died, the child can get the right for the share of this property, and the payment of child support should be continued. And also there are a lot of petitions to include these obligers in social works in case they avoid payment. The proper support should be provided, so there should be more rigid punishment for those who do not pay, who create these debts. So this person should work. So the state provide compensation. This compensation is provided by the state. So the obliger should return this money, and he should bear the responsibility for his child, for the provision of needs of his child. Also, the part of a child in the management of this money. So there should be proper mechanisms in place in order that the child could participate in the management of the funds, and also introduction of responsibility of those persons who get this child support in case of mismanagement of this money, because people who are obliged, they say that these people who get this money, they do not use this money properly, and this money is not used for a child. That's why we believe that this work that we have already started, that this will have a proper consequences concerning changes into legislation. And I would like to give the floor to my colleagues who co-authored this law, and I would like to thank the Committee of the Supreme Council on Youth and Sports, especially Artur Palatny, the head of the committee, who helped us in this work, and we would like to thank the committee for helping us in introduction of changes to this draft law. So we give the floor to Svitlana Savytska.
Thank you to all present audience. I would like to tell you good afternoon. As concerns the scrutiny on child support collection, there were very many statements, applications to us that they can't get child support amounts, or they are postponed or delayed payment of child support. Understanding that the question concerns children, we try to harmonize everything, and we and the Verkhovna Rada has been submitted the proposal that the child support amount can be received under simplified procedure. Previously, it was only by court decision, and the draft law proposes to the custodial parent to use a simplified court procedure, because from the date of initiating court proceedings until the end of court proceedings, the period is 3 days. This is very positive, as well as there is other positive news. The person addressing the court for getting child support, this individual submits relevant documents and application, and the relevant document that she is a custodial parent, and then the court has their has the relevant powers to award child support. The procedure is very simple. In the process of proceedings, per one child, one quote. In this case, for violations not to be present, there are some persons who have high incomes, so limitations were also applied. Such child support will be limited to 10 living wages. If previously more money were provided, in other cases an applicant can apply and collect more money. There is alternative but simplified procedure was focused on average families, average households, where 1/4 of salaries will be about 2 to 2.5 thousand hryvnia. This is not enough for subsistence of children to cover their living costs. But anyway, this amount can help mothers. I would like to add why this is so important. It was a guarantee that this would be more than 1/4, despite of number of children. The third is we are talking about simplification of procedure. There will be enough just to start getting child support for children not to suffer from this civil proceedings, which are long, which sometimes 1 year long. The support child payers say this is too strict procedure if they have other costs, such as costs of his parents living, or costs of maintaining his new family. The debtor anyway should pay, because the children's interests dominate over the interests of their parents. A father who does not agree to the amount of awarded child support amount can apply to court seeking decrease of child support amount, and there he will be proving why the amount should be decreased. So far, the defendant had the right not to appear in court twice. That is why court proceedings could be long because of such unfair behavior of the parties. The draft law now will said that you should pay 1/4 of your salary, of your gains, of your incomes. This is in focus. The child support should be equal to 1/4 of your incomes. When we mention then the child is in the focus and the child needs this money, not father and not mother, courts should keep this in mind, and this draft law is the first step to conscious parenthood, conscious parentage. The child should be supported by both parents in order to become a full-fledged citizens of society in future. So this is what I wanted to say. My colleagues will describe other important aspects. Good afternoon, colleagues. I'm glad to see you here and to continue. It is worth noting that the judge of the highest special court, Oleh Prostybozhenko, was a member of our work group. Her pieces of advice were very valuable, and we drew relevant conclusions based on her professional advices. So the courts will we want courts to understand that this is the result of our joint efforts with the judge, with the professional, and we developed these approaches together. My colleague Svitlana said that about the draft law, it would be focused on 80%, 90% of collectors of child support amounts, all categories of alimony payers could be divided into 3 categories. First is low-income citizens. This law cannot resolve their issue. This question is addressed by some social welfare laws. There is special program of social welfare. This mechanism could not be fixed in this draft law. About 80% are citizens who gain incomes at work, so they have incomes in the form of salaries or wages, and for them the collector of child support, the applicant, should not go to court according to this new law. So taking into consideration the possibilities of payers to hide property or to state minimum wage in their records, official records. They try to pay minimum amounts. This category of citizens is proposed by the law to pay amounts for hidden property or hidden incomes. Previously, the law said that the court takes into consideration the financial status of the defendant. Nowadays, this is a fixed amount if a person's income is flexible or not set. The person which is employed, he can regulate his income amount. The draft law changed this rigid hierarchy of methods of child support collection. A recipient of child support shall choose the method. The court can change the amount, but this is the child support recipient who decides on the method of receiving this child support. If a payer has property, cars, visit foreign countries, but demonstrates low wage, minimum subsistence level, then the claimant may go to court and demand higher subsistence support level. The claimant may now go to court and prove the costs of these payers in order to prove their higher financial status. The tax authority is the first instance where one can get information about property status of an individual. The second body, the second indicator is trips abroad. How many euros per day this person demonstrated in official application for a visa or for a visit according to visa-free regime. These methods are indirect ones, but the court is allowed now to assess the property status of a person in this way. Child support payer may prove that this is heritage, for example. Heritage is not included into the amount of child support payable. So I would like to accent that child support, that the recipient of child support proves the costs of the expenditures of child support payer. If then the defendant should prove that these expenditures were made from the amounts which are not subject to withdrawal or deduction of child support from. So this mechanism will be possible in a full-fledged court proceedings, but anyway, claimants will be able to use this mechanism, and it is focused on higher income category of citizens who wants to prove that this person violates his obligations and hide child support from the child. I would like to give the floor to Hanna Haro, my colleague.
I would like to thank Kuleba Mykola Olegovich that he cooperated with our committee, and I would like to speak about the novelties my colleagues didn't mention. First, the minimum child support was 30%, and now this will be 50% of subsistence level, and we will raise it further. And also, the novelty is the additional expenses for the child. So when you apply the petition, you should not pay for this in court, and this should be used in the interest of the child. So additional expenses in courts are also for free. So there should be there is a percentage for non-payment of child support, and now we introduced the also interest for non-payment of additional expenses. And private entrepreneurs, they pay taxes, and how the arrears are accrued if this obliged do not pay child support. So this arrearage is calculated based on income, based on locality where this person lives. It was difficult to calculate it. People should have addressed to lawyers, and there were a lot of complaints about it. Now this draft law establishes that if the debtor is physical person entrepreneur using simplified system of taxation, so this will be based on average salary, and this will be 2,200. So if the person doesn't work, the arrears calculation will be the same. Also, if the obliger receives the income abroad, especially if there is no agreement, how to search the evidence what sums he got. This draft law establishes that if there is no direct evidence about the amount and we cannot find this information, then this will be calculated based on average salary for the locality. Or if they find this evidence, so this arrears will be recalculated. Also, fines established, because now this there was a controversial practice on this, and Mykola Mykolaievich addressed high specialized court in order to establish proper position. First, they calculated through one practice as it is done according to the norms of civil code. Now there is another practice, and some changes were introduced concerning the fines in case of deaths, and we hope that this will change practice, and also it will change the opinion of the High Court. So if the payment is not made, and you know that child support is important and people should be responsible for implementing their responsibility. And we proposed several important novelties concerning responsibility of obliger and responsibility of the person who gets this child support. So this should be done in proper way. Those persons who get child support, they should use money properly, because sometimes some people ask for unreal money and they use it for other purposes. And there is no responsibility for people who get these funds and they use it for other purposes, not for their children. And when we developed this draft law, as key aspects, we established that child support is the money for the child, and the child should have the opportunity to live on this money. And also the responsibility of both parents. So people should be taught to be responsible for their children. You cannot say that I won't pay to you, I will pay for you less if I have a child in another family. How these children differ? If you want to bring children into this world, you have such right, but you should support your children, and this is your responsibility. And we hope that in the future we will have more regulation on this, and there will be responsibility, and there should be verification of the use of this child support, but there is no strict responsibility. And we also understand, and it should be proved, that not the salary is main indicator what sum should be got. We should understand the needs of the child. And if a person works and he or she gets additional payment, so I have the right to have 25%. Not only those, but this means, but the money that is needed for the child. Some things are outside the attention of the Supreme Council at the moment, but we hope that we will be heard and taken into account, because children are our future and a lot depends on this. And also the information about the lawyers. So this petition can be submitted in the courts locally, and it can be done in the region where the plaintiff resides, and also you can address in the place of where obliger lives. So using this opportunity, I would like to say that first my colleague asked in Facebook whether she understands correctly that the payer won't be able to change the amount of support. You should understand that he cannot change the way how these money taken away. So the share of profit or the rigid amount. But this there can be variation. The court can reduce support from 1/4 to 1/10, 1/5, depending on how the plaintiff confirm that this money is really needed. So they can reduce this amount, but not less than 50%, but this sum can vary. But so the way is established only by the plaintiff. So Anna said an important thing concerning additional payments. There was no mechanism a priori, and also in the family code, we have limitation concerning the application of civil code to family affairs. And we introduced such a responsibility, and we went even further. And also, we established new norms. What I want to say is that the responsibility of the obliger will start not from the day when the decision of the court is provided to the plaintiff, but in 7 days when the plaintiff said that this amount should be paid for a child. So 7 days are provided to the obliger in order to provide to a mother or a father, depending who is a plaintiff, to provide his half of such additional expenses. If he doesn't do this, there is a responsibility in place. So this is 3% a year. So in all this time, the plaintiff will apply to court, and this responsibility will start from that day, not as it exists today. And now we can do it only after the decision of the court. So there is a delay. And there is a progressive element here, because the idea that is provided in this law is that the obliger should understand that he should pay child support from the start of the from the birth of the child, so it is not about court decision. If a child was born, a person should understand that I should support this child, and if you do not support the child, then there will be mechanisms of responsibility. And this idea of the law is to prevent a situation when the obliger could think, oh, I will sell my flat, or I just be unemployed, and then this way won't pay. So we should provide information to people that children is a serious thing, and this is a serious responsibility. And when someone comes and say, oh, there is some child support, no, I say child support is really serious. This is the property of the child. Child owns this money. So information about the lawyers. By this draft law, we clearly established that it is not allowed to stop the proceedings on child support issues if there is some problems and disputes about place of residence of the child, or participation of one of the parents in upbringing of the child, or in case of other issues. So other side can apply. And for example, if there is an issue of parentage, so now they won't have such gaps in legislation. And lastly, I would like to thank my colleagues from the Association of Advocates of Ukraine who helped us and who were co-authors of this draft law. And once again, addressing those who for years cannot get child support. We understand that maybe by this law, we won't be able to be more rigid to non-payers, but the work has been started, and in future there will be more rigid punishment. These are the works and prohibition of going abroad, or even imprisonment, because in many countries there is such a proceeding. So also we discussed the issue that in some cases where it is not provided by the family because the family is vulnerable, and they get support from the state, and they in this case the state also can be plaintiff in this case concerning child support, and the state will compensate this to the custodial parent, and also the state will bring obligers to responsibility in different ways. So in the circumstances, and also the person can be on the wanted list because of this, because some people do not know where these obligers reside, and in such a case we believe that in the future it will be easier to get child support, and less people, those who pay child support, in order that people do not avoid payment of child support. Please introduce yourself and ask questions.
Good afternoon, Anastasia Dyakova, Project Office in Health. I have a question beyond the topic. Do we have any regulation of the format of child support payment? Should it be cash or cashless payment? And how confirmation of paid amount is submitted? Why we can't pay them just like taxes? They could be withdrawn and that's all, deducted from incomes. The first part of your question is concerns we pay child support both in cash or in a cashless form. It doesn't matter. This is not regulated. If a person seeking child support provided bank details to the executive service to enforcement service, then the payer may pay to his her bank account, or by post office transfers when a recipient of child support does not inform about her intention to get child support amount in certain form. So this is a question for payer of alimonies. He should have a receipt if he pays in cash. This payer should have a receipt from his former wife that she has received alimonies. If there is no word alimony or child support in this repeat, then this would not be the evidence of his payment of alimonies. We should understand one specific feature in Western society. You have bank history, you can be bankrupt, or you have can demonstrate strong financial status, of course you will be paying your child support which you are requested. In our country, those persons who are believed more prosperous, more wise, who do not pay child support amounts. This is the matter of our mentality. As a lawyer, I can find ways to decrease the amount payable, but I will never advise my client not to pay his court-awarded alimonies. There are no factors to force a person to pay child support amounts, because in our country individuals even manage not to pay taxes. So automatically deductions are made just like taxes are deducted. The category of problematic payers, this is the category of payers who do not have property. For him their social status does not matter. No law will be able to force them to pay something for their children. I would like to add, I agree with you that the society should live with the idea that persons are not moral and persons are unfair, and when they do not pay their child support amounts. When I visited Moldova, I saw big boards saying that here are the individuals who do not pay child support amounts. So such persons should be ashamed of this situation. And I am for introducing this aspects into school curriculum. We should nurture children that they should know that they should pay child support. We will see debtors in databases, and those who have high amounts of unpaid alimonies will be easily visible. If you are working not in a shadow sector, you just go to your accounting office at your place of work and submit a statement just saying that this is you want your amount of child support to be deducted from your salary. In our country, women sometimes also do not understand that their former husbands may give them money just not as alimonies. I have one small question. A person who is not a lawyer, and such person can ask, if a child is an owner of alimonies, why mother has the right to dispose of these amounts? For you to understand, now parents dispose of all the property of their children which are under 14 years of age, and and as concerns children under 18, which are not capable to take legal actions, the custodial parent has the right to dispose of child support amounts. But now we included the provision into the law that such a custodial parent should spend this money in targeted fashion only for a child. This is the addressed support amount. So in some cases, alimony's amount is 20,000 hryvnias or 200,000 hryvnias. When 1,000 hryvnias is amount of child support, this amount is easily traceable. So when we talk about big amounts of child support, parents should understand what for they receive these amounts. This is not a problem that children are owners of money and parents being not owners of these alimonies, they still can dispose of these amounts. When parents were owners of these amounts, they could dispose them in voluntary fashion, even to set them on fire. But the structure was different. The parent was the owner, but she could not use them in any way. So we were an exclusion. Our law was different from European laws. Our legislation had the mechanism of transformation of debts, the right for child support transformation. The child, being not the owner, was receiving property instead of child support amount, instead of money. It was not logic. It was not logical, and Mykola Nikolaevich also said about civil liability. If a recipient of child support amount, the legislation allows to the second party to go to courts. Parents go to courts to get a decision where alimonies are spent for. If they are paid for not for the right purpose, then a child which is older than 14 can go to a court with a claim saying, where are the child support money? And this way the child, starting from the age of 14, can collect this alimony from custodial parent and also to dispose of this money himself or herself. We need to address civil legislation, regulation of individuals' actions. Thank you for your detailed response. Other questions? Lawyer's assistant, are there any changes according to the alimony for students of daytime institutes. No, nothing has changed. The procedure is quite different, but it was different. Everything remains the same, taking into account some additional charges which cannot be payable for such a person. No questions. Thank you. That's the end of the press conference.